Okay, absolutely. Mr. Chairman, we are live now.
All right, welcome to Judiciary. We're going to be considering two bills today. First, Senate files, excuse me. First, Senate File 39, Digital Identity. A little bit of a new topic for the Judiciary Committee, but I'm confident they can handle it. And Senate File 19, Public Health Emergencies, Immunity Amendments, a little more in our wheelhouse. We're going to start with Senate File 39, Digital Identity. This is a product of the Select Committee on Blockchain, Financial Technology, and Digital Innovations. Have with us my co-chair from the Senate, Senator Rothfuss, and we are joined by former Representative Tyler Lindholm, who was on this Select Committee. I believe the two of you are going to present this bill. Is that what we're going to do?
Yes, Mr. Chairman, I'd be
Senator
happy to
Rothfuss?
start.
Okay.
And Mr. Chairman, I do have another meeting coming right up, so I will start and then I'll hand over to former Representative Lindholm. We also have online, I believe, Mr. Dazza Greenwood, who was part of the working group that worked through the Blockchain Select Committee to prepare this legislation. So
Clarissa, do you have Mr. Greenwood in the waiting room?
Mr. Chairman, I do, and he has been admitted to the meeting.
All right, you can turn on your camera, Mr. Greenwood. And then we'll just let the three of you present together and see where it takes us.
thank you, Mr. Chairman. Mr. Chairman, Senate File 39, Digital Identity. It's a short bill and relatively straightforward. We'll go through what it currently does. A tremendous amount of time actually went into getting it to this point, and it serves as a foundation for what we hope to be a substantial amount of additional work. The concept here with the digital identity is the idea of trying to formulate your digital presence in a way that we can then assign rights to it. A lot of what this does, you could probably think, well, we could probably already do that under statute, and that is probably true, but it's not clear in statute and it's not unambiguous. So the work of the Blockchain Select Committee recognizes that a digital identity and a representation of yourself through online operations, internet, blockchain transactions, banking, we already do these kinds of things, but it's a little bit ad hoc. And we wanted to flesh it out and provide clarity because these types of transactions are going to be more and more powerful and more important moving forward. Other states and other countries have also grappled with concepts of privacy rights, but they've done those on largely an ad hoc basis. So GDPR, which governs privacy rights in Europe, and the CCPA and later amendments are an advanced privacy rights construct on a West Coast state. And we're taking a little bit of a different approach because of the work that we've done in the past with the blockchain technology and digital asset custodianship, where we want to build up from the idea of a digital identity, empower that, and then ideally in the future, hopefully next year, come back and look at privacy rights and property rights as they relate and interact with your digital identity. A different approach to how other states and countries have done it, but hopefully one that is a more substantial approach to build off of. And again, we spent a tremendous number of hours with a lot of great legal minds coming together to work on this draft and really just get to the definition phase. So that's what we're going to see today, is a definition and a minor empowerment of that definition. Walking through the legislation on to page 2.
Senator, just
Go ahead.
to drive that home. This bill is simply a definition.
Mr. Chairman, yes, it's two definitions.
Or two definitions, yes.
References to those two definitions, and then a link to the Uniform Electronic Transactions Act, effectively as a baseline empowerment of those definitions, as we'll see.
Go ahead.
All right. I'm actually going to strangely start, if you will, on page 3, the bottom of page 3. And this is just based on legislative construct, that's where the beginning ends up being, which gets to the actual definitions, which are put into statute in Title 8, which are general definitions that apply throughout the statute. And you see as used in these statutes, unless the legislature clearly specifies otherwise, 2 new definitions, which are on page 4. Personal digital identity means the intangible digital representation of, by, and for a natural person over which he has principal authority and through which he intentionally communicates or acts. So there's a lot loaded into that definition. And that was the bulk of the work that we did in the off season. And Mr. Greenwood, who's present here, can go into the thought behind each of the words and phrasing after I take off in a few minutes. Organizational digital identity is parallel language, but we recognize that as a minimum, as we move forward, we're going to want things like businesses and organizational entities to have legal standing, and we're going to want to imbue those with separate rights from what a person is going to have, a natural person. So we just set up the construct from the beginning, organizational, individual, as that delineation, and then theoretically in the future, we'll empower them accordingly with privacy and property rights. And you'll hear in public testimony some of the thoughts behind how we're looking to do that. So we put that into Title 8. And now, again, traveling backwards a little bit to page 2, or bottom of page 1 onto page 2. Now we're creating Chapter 30 of Title 40, the Digital Identity Act, which begins with definitions, and these definitions are simply references to those general definitions that we put in Title 8. And then the only other thing this bill really does, as you can see on page 2 onto page 3, is clone the language for the Uniform Electronic Transactions Act, which is already in Wyoming statute from a few years ago, to empower your digital identity and your organizational digital identity with parallel power and authority to what you have with your electronic signature through UEDA. So again, not a magnificent step, but sort of the first step to recognize explicitly that your digital identity is representative and authoritative of your actions. And you can see in Romanet 1, acts taken through a personal digital identity are attributable to a natural person if they were the act of the natural person. The act of the natural person may be established in any manner, including a showing of the efficacy of any security procedure applied to determine the natural person to which an electronic record or electronic signature or other act was attributable. Parallel language in Romanet 2 for the organizational. And then Romanet 3, again, is UEDA language getting to the intent and context of the circumstances surrounding the creation or execution of the event. And at this point, Mr. Chairman, that's what the bill does, but it's a foundation that I want everyone to contemplate what we're looking to in a broader picture, where we want you to be able to act to this authoritatively as we get into a blockchain realm. That's going to be typically through public and private key exchanges, where if you have, for example, a business registered through the state of Wyoming that has an organizational digital identity and a public key present, that can be used for transactions with any company around the world authoritatively. You as an individual, if you opt to have a digital representation of yourself through your digital identity, can have a public key and you know your private key, and you can authoritatively engage in transactions. You can screen information at your desire. There's a great use case that we kind of contemplate as we began this discussion. When you go in and you're buying a 6-pack of some delicious IPA, and you walk up and you want to prove your age to the person at the cash register, what do? You take out your driver's license. You hand that to them. They know where you live, what your name is, whether you're an organ donor, all sorts of things that you don't necessarily want them to know, because what you want them to know is a simple binary question. Are you 21? Yes or no? Digital identity concepts are trying to empower the ability to select what information you share with whom, when. And there are a number of commercial products out there, frameworks, organizations that are moving towards this. We're trying to be entirely technology neutral and build a legal construct that enables all of these technologies to start in Wyoming and take hold here. There's a lot of enthusiasm in that industry and space. But this doesn't pick any of those technologies. It doesn't say you have to have a digital identity. It just creates that baseline framework, Mr. Chairman, that we wanted to make sure was there so that industry can come and work with us. And I'll stop there, Mr. Chairman, see if there's any questions, but then get to Representative Lindholm and Mr. Greenwood, and I will be leaving in about 3 minutes, Mr. Chairman.
And Senator, I like to take the example you gave and add to it a little bit, because the example I like is my daughter who's purchasing a rated R movie at the supermarket, and it requires her identification, and the checker at the stand is a registered sex offender. And when when my daughter provides her ID to that gentleman, he knows her address. And when that's completely unnecessary, to your point, that we reach a place where we can answer and prove only as you call it, the binary question: Are you of the age necessary? All the other information doesn't matter. Question, Senator, what did you do to this bill to turn it blue?
Mr. Chairman, we had a number of meetings among the working group members after we first drafted the bill that came to the Senate. But the only thing that's changed is on page 4, when you look at the definitions. On lines 3 and then mirrored below on 12, the original definition we had was over which he has dominion and through which he intentionally communicates or acts. We were kind of uncomfortable with the word dominion, and we spent some trying to come up with a better term for what we were looking for. Sovereignty is the word we want to use, but sovereignty has so much baggage, right? So we couldn't use that, but it's like the perfect word with tremendous baggage elsewhere in statute, so we punted on it. We came up with principal authority, which didn't seem to contradict or overlap any other concepts, got the point across. Principal authority means that you're the initiator of the authority. Effectively, you've got that primary intrinsic authority. And so we decided that was a better 2-word phrase to capture what we're looking for than dominion. And that's the only change, twice.
Sometimes these meetings are a blur to me, but I feel like I may have spent 8 hours discussing sovereignty in
Yes,
this bill to only see it not in the bill.
that may be accurate. Yeah. And Mr. Chairman, my apologies, but I have to run to another meeting. You're in good hands with some incredible people that we have here, and
All right.
look forward to chatting with you about this later. Thank you all.
Thank you,
for your time.
Senator. Mr. Lindholm,
Hey, Mr. Chairman.
good to see you.
Yeah, likewise. Mr. Chairman and committee members, this piece of legislation comes from, I know it seems like a really super simple bill, and realistically what you're looking at really is a simplified version, but the reality behind this piece of legislation is it comes from a monster amount of work trying to figure out this digital identity piece. And the reason, Mr. Chairman, on why I say there's so much work put in and yet this is fairly simple is because this is a big dog. This is a monster. This could be one of those next big things for the state of Wyoming. And I'm not talking about buying a couple cans of booze or a rated R movie or something like that. I take a very different stance on this and why I think it could be a bigger deal. And it has to do with online accounts. And it has to do with when you're signing up for a bank account or something like that. The federal government mandates that you do something called BSA standards, which stands for the Banking Secrecy Act. That was first passed in, I think it was 1971, Mr. Chairman, and it was amended in the 2001 Patriot Act. all of which came well before where we are currently in technology with online banking and these digital asset exchanges and these community banks even having the ability to provide that opportunity for you to cash checks online. And so we're faced with kind of some old world regulation, and how does the state of Wyoming adapt to that to allow this to happen? Because currently, right now, if you open up an online account, I don't know, Mr. Chairman, if any of your members of your committee or yourself have ever opened an online account for a banking type institution. But we've got all these kind of every outfit out there has their different kind of rules set up in place on how they verify your identity. Mr. Chairman, they've got to do what's called know your customer anti-money laundering standards. So they've got to complete that process. And how do you do that online? Well, different outfits do it in different ways. One outfit will have you hold up your driver's license in front of your face with a newspaper from the day you're taking the picture, proving that it is actually you. And then you've got to scan your identity and all of these different aspects, trying to conform 2001 technology into 1970s and 2001 technology. 2001 doesn't seem that long ago, but folks, I joined the U.S. military in 2001, and that was 20 years ago. So it has been a little while. And so for me, that's why I'm excited about this legislation. You'll notice it does go into Title 40. The new language does right there on page 1 goes into Title 40, and that's your trade and commerce statute. That's your trade and commerce title. And then it creates a new chapter, and that's Chapter 30, Digital Identity Act. And so, Mr. Chairman, that's creating essentially a placeholder for hopefully one day we can figure out that loophole in KYC standards where we can allow these little community banks like my community bank, Sunnat State Bank, and these other institutions that exist in the state of Wyoming to be able to grow outside of their little communities and maybe do online banking in a way that no other jurisdiction can. And that's what this is about, is allowing our little community banks, our little businesses in the state of Wyoming to grow outside of our border and expand their businesses and new businesses to come in. And I think that's really where the merit of this legislation stands, is as Senator Rothfuss said, or Chairman Rothfuss of the Select Blockchain Committee, it does create that foundation, which I think is important. We could not figure out how to, pardon my language, Mr. Chairman, how to bastardize the Banking Secrecy Act. And that's still a work in progress. I do know that there is some interest from some U.S. senators in the regards to fixing the Banking Secrecy Act to allow the state of Wyoming more flexibility in this regard. And but I'm not speaking on behalf of that individual. I'm speaking on behalf of myself. So with that, I'll stand for any questions, Mr. Chairman.
Representative Yin.
Thank you, Mr. Chairman. Mr. Lindholm, I'm just curious where you were testifying from because you did not announce that at the beginning. Thank you, Mr. Chairman.
Hang on, I think.
Mr. Chairman,
where are you testifying from?
Thank you, Mr. Chairman. I'm testifying from my kitchen table. And I'm usually in my basement, but I've got too many political signs down there. So I figured I better move my laptop upstairs away from said political signs.
So, Mr. Lindholm, when I want to open a bank account, I just text my banker and say, I need to open an account, or I want to get this loan, or whatever it is. I just text him. So how does that world change for me in Wyoming, or does it really, or are we really talking about bringing in some growth, some outside Wyoming? It's outside the world that's banking. Is that what you're talking about?
Mr. Chairman, I'm talking about both things. So when you text your banker, that's an existing relationship that you already have, and that banker has already established know your customer and anti-money laundering standards on you, and they've got proof of that. They can share those that proof of concept inside house. They can't share that with another institution. Mr. Chairman, if you were to contact another banking institution that you didn't already have an existing relationship with, you would have to prove that know your customer and anti-money laundering standards all over again. Fortunately, most of us in the state of Wyoming, I suspect all of us, in fact, have had a bank account for quite some time. And So it's really not that kind of a wild concept until you go to online, until you open up a new account online, and then all of a sudden it's pretty burdensome in that regard. But this putting in this in statute, so that provides that opportunity where hopefully something would shake loose as far as our regulatory entities, the Division of Banking in the state of Wyoming, those types of entities where they would be able to utilize this type of legislation possibly. But also, Mr. Chairman, I think this is just like a lot of the piece of legislation that we've passed in regards to ICOs and all those things. This puts a flag in the ground and does something in the state of Wyoming that no other jurisdiction has even contemplated, and provides the most important thing. And I know the legal minds on your committee, such as Representative Oakley and yourself, and I'm sure I'm missing some attorneys that I probably don't know.
Representative Crago, but he's not here right now.
Representative Crago is one of my favorite new legislators.
And then Representative Yin, we give him an honorary Juris Doctorate.
Well, that's handy, Mr. Chairman. I don't know why I didn't get one of those. But I think that legal precedence aspect, Mr. Chairman, is so important. And that's why Wyoming has seen success. That's why IOHK is domiciled in the state of Wyoming. That's why Kraken's moving here. And the list goes on these large institutions, because legal precedence means the world to larger institutions. And so, yeah, I guess that's a long way of answering your question, Mr. Chairman.
I thought I saw a hand to my left. You're just eating chips. Maybe that's what it was. I had the barbecue ones earlier. I'm good. Questions for Mr. Lindholm? Oh, it was you, Vice Chairman Washit.
Thank you, Mr. Chairman. Former Representative Lindholm, good to see you again. As we were talking and listening to the good senator present the bill, and he was talking about this being foundational to eventually establishing property rights and privacy rights associated with this digital identity. The first thought that popped into my mind is, are there any responsibilities to go along with those rights? Will these types of digital identity also carry with them some social or civil responsibilities?
Mr. Lindholm?
Yeah, thank you, Mr. Chairman. And to Mr. Vice Chairman, great to see you, sir. Honestly, when it comes to digital identity or this type of legislation, this law doesn't exempt anybody from identity theft or any other type of criminal statutes that are in existence. But there is a right and responsibility throughout the legislation as defined. Specifically, Mr. Chairman, on page 3, under Romanet number 3, I think an important part of this piece of legislation is starting on line 10, and that is shall be determined from the context and surrounding circumstances at the time of its creation, execution, or adoption. So, Mr. Chairman, and to you, Mr. Vice Chairman, to me, that essentially means that that proof of digital identity for the execution of whatever type of transaction, because this is only for transactional type aspects. In that regard, that would mean it's only for that one execution per time that you actually utilize that digital identity. So it's definitely not written as a carte blanche.
Any other questions for Mr. Lindholm? All right. Got off pretty easy, I think.
Thanks, Mr. Chairman. I was expecting you to mess with me a little bit, so I'm glad to get out with my hide still attached.
I have, unfortunately, so many questions about this bill that I might have to follow up with the email on them to you. All right, Mr. Greenwood.
Thank you. Thank you very much. It's an honor to be here. My name is Daza Greenwood. I run law.mit.edu. That is an initiative at MIT that is focused on applying engineering to law, and we call it computational law in particular. And I run civics.com, which is my private company. And in all of my endeavors since the 90s, when I was a government lawyer, the same issue's been coming up, which is the need to, well, solve, if you will, for digital identity. It's been really a missing piece. And it all starts, I think, with getting the right legal framework in place. But we can still see today, um, when we think of digital identity, uh, um, Representative Lindholm mentioned accounts, and this really being about like an account that we use. The accounts that we have from Google, from our employers, our patient portals, government IDs, social media, of course, they're all these fractions of our identity. And the one thing that they all have in common is that they're issued by somebody else. They're, in a sense, owned and controlled primarily by some other entity. They can set the terms, turn them on or off, change them. It's like a privilege in a sense, at best. And yet, I think it's just plainly obvious now in 2021, the world is going digital. The activities we do in commerce and with government and in healthcare and education, every part of our life and the economy and society increasingly is happening, like the authoritative activities happening online. But where is the space for our identity? The one that arises from us. Um, that's almost implied in most legal frameworks, that preceded the digital age. Um, and we did a very careful um, analysis of Wyoming statutes and the Constitution and the rules leading up from being a territory to a state. Many places where individuals were identified, and there was a lot implied in the individual, and in the person and in the citizen and the resident. They're the ones that needed to consent to be governed. They're the ones that from whom authority arose for them to conduct their affairs. They were the well, to use the word we used to use, they had dominion in a sense over their identity. And that was a building block, and it made perfect sense. That's all been confused somewhat based on the way architectures have evolved online. And so and some of this is just having legally, there's something missing that is now solved in this legislation, which is the first building block, which is itself a definition, just a there, describing a, a person's individual identity, the one that is of, by, and for them, through which they have principal authority, principal PAL, like in agency law. The authority arises from them. Um, and and uh, and after much drafting and back and forth and many cycles of feedback from broader communities, including at MIT, where we've circulated this in classes and in talks and sought to get a lot of feedback on this, and in other circles as well, trade associations. We think we've got it, and part of the reason I'm such a fan of this definition is precisely because it is so simple. Right? We really couldn't have made it more rudimentary, and it's of the same size as the other definitions in the chapter with the definitions that apply across Wyoming law. They're all like 10 to 30 words, and we think that's that's what we were shooting for. And I think we felt that if we couldn't explain this in that few words, it probably wasn't ready for a definition that would serve the role as to be a building block that could be referenced by and ultimately supported and reflected in other parts of Wyoming law. The first other part, as has been said many times, is Uniform Electronic Transactions Act and the rules of attribution of acts to people online. And that does get us toward the accountability or the responsibility that was being asked about a moment ago. So one is responsible for the acts that they take through their digital identity, and I think looking ahead, if this definition is acceptable and is adopted and enacted in future sessions, some other areas of law that seem like they may be good fits, may be identity theft and possibly section 63902, the unlawful impersonation through electronic means. You know, we think the identity that is a person's identity should not be subject to fraudulent or criminal impersonation. So like that would be a perfect extrapolation of this. You can imagine privacy, but also civic and commercial legal frameworks also benefiting from this, so that we can start to, in a reasoned way, adopt a sense of individual identity, through the law. And so, with that, I want to, I think, pause my remarks and just say that I am very much in favor of this legislative definition and of this measure. And I hope the committee, if you believe it is of value and timely as well, will seek to adopt it.
Mr. Greenwood, how many states statutorily define personal or digital identity?
So I think that this formulation might be the first of its kind. There are many examples of digital identity in different ways being defined in statute. I mentioned identity theft, for example, and personally identifiable information and breach notification. And digital identity, if you do just like a Westlaw or Lexis search or something, comes up all over the place. That's partly why we added a word here to get to which facet of identity are we talking about, not the identity that is coming from others, which people certainly have rights and interests in and can cause them harm and benefit. But we added personal digital identity to distinguish this and limit it to the building block, which is the one that sources from the person, or sometimes colloquially people say self-sovereign or self-sourced identity. And so this is something that's been talked about a lot in digital identity circles. It was the center of something called NSTIC, National Strategy for Trusted Identities in Cyberspace, which was a public-private partnership that NIST and GSA and Homeland Security ran with a bunch of industry groups, where they were attempting to come up with private sector-led standards for this type of identity that comes from people and that can be relied upon by others. And so there's been a push towards something like this, but this is the first of its type to be articulated in a clear and I think very valid manner in statute. And honestly, the people who have been barking up this tree, we've always felt that statute was the right place to at least define the terms and allow others to build toward those terms. And so we hope that you will be the first to adopt this. And part of the conversation in the committee did involve the hope and maybe expectation that this definition might just have legs, and we might in fact see this adopted in other jurisdictions to follow, because it does fill a very well-known need.
Is the same true for organizational digital identity?
Yes. Well, I'd have to do some more checking there. The most important area that is reflected in various layers of law, I'd say, is the legal entity identifier, LEI, which is more from banking and finance and like FinCEN, financial crimes enforcement kind of angle. And it's basically they're seeking to have a unique identifier for each legal entity, as opposed to the tangled web we have of so many identifiers right now. And that makes it difficult for, commerce and regulation, enforcement, investing and analysis and all sorts of stuff. But that's an identifier that's going to come from a registry if it matures at all. There isn't an actual legal definition of the entity. And just to of the digital, a definition of the digital legal identity of the company. And just to put that in context for a moment, just a couple of days ago, I was working with a startup who is seeking to build apps and services for companies to take information from and connect information to their Google business identity. And so when you look at Google Maps, you'll see lots of companies and you'll see them on the map and you can click on them and you can see their store hours, their contact, their website. They're filling a gap here that I would think in the first instance is that of state government in the United States to fulfill. The state government through the Secretary of State gives rise to or is the authoritative source of when a business is born by incorporation or LLC formation. And there you can't go to a registry, but again, there's no there. And so we have companies like Google and of course Dun & Bradstreet and many others that are filling the gap digitally, but they can only go so far. At some point at the bottom of the stack, we need an authoritative identity and a profile that entities can act through. And it'll just end by saying, if you think of things like phishing attacks, when people get an email purportedly from their bank or from some company and they start to do things, how can they know whether this is the company it purports to be? Again, the ambiguity here and that's being exploited or just causing confusion comes partly because we don't have an authoritative organizational digital identity. And having a legal definition, we think, is a real good start. And ultimately, things like the APIs and other reforms happening in Wyoming Secretary of State's area can adopt that and can extend that into other areas of law and practice.
Questions for Mr. Greenwood? Mr. Greenwood, the moment I realized I existed is when I had a Wikipedia page. I was online. That's my digital identity. All right. Thanks, Mr. Greenwood. Appreciate you. We'll see you more of this. I'm sure we'll see you this interim.
Thank you.
All right. Anyone else in the digital world wishing to make their identity known and testify on this bill?
Mr. Chairman, I don't see anyone with their hand raised.
All right. Thanks, Clarissa. How about in the physical world wishing to make your identity known? Testify on this bill. Nope. All right. All right. We'll close. Oh, Representative Fortner. Come on up. Welcome to the digital day of the Judiciary Committee.
Thank you, Mr. Chairman. I think I view this as an invasion on privacy.
Oh, sorry, Representative Fortner. Can you introduce yourself?
My name is Bill Fortner, Representative Fortner from District 52, Campbell County.
Thank you.
Thank you. Like I said earlier, Mr. Chairman, I view this as if we buy into this in the state of Wyoming, we're going to be, I think, violating privacy laws. You know, we might not realize it in the beginning, but there's so many avenues right now without this. They know more about you and your family than most of your inner works.
Sorry, Representative Fortner, who is they?
Pardon me?
You said they know more about, I don't know. Who's they?
Government, anybody out there,
government.
organizations. I've known people that's applied for jobs and they can't get the job because they go to apply and then they vet them over Facebooks for who they really are. This kind of technology is dangerous at best. I'll give you an example. I went for a doctor's appointment down in Colorado here about 4 weeks ago. I got a back injury, so I get down to the doctor down there and I just called and made an appointment. I get down there, this guy knows more about me than most of my relatives. And technology is so accessible and so acceptable anymore. But I think we need to relate back to where Donald Trump was at on his last months. And when the Russians broke into the cybersecurity and they interviewed the guy that was the head of that organization. And they asked him, where's the United States at as far as protecting their privacy and all the documents they have. And he said, the United States compared to the rest of the world is like a glass house. So we start giving out this kind of information in Wyoming. And I keep hearing block. And what blockchain is, it's a bunch of technology hooked together like a chain. It's just in little blocks. How do we know that that block's going to end with us, or it's going to go clear over here? I mean, it can go anywhere. Without our control, we just give them a nugget and they can just keep hooking on and hooking on and hooking on. We actually lose control before we ever had it, really. I think it's a dangerous technology. I think Wyoming would be better not to accept this. I mean, you can listen to them. But I think once we give this kind of information out to the rest of the world, I think we're in trouble. I want to thank you for your time.
Representative Fortner, do you believe that you should own your identity or that the government should own your identity?
Do I believe what?
That you should own your identity or that the government should own your identity?
I believe we all have personal access to our own identity and nobody else does until we give it to them. When they steal it, that's
And
just exactly.
Representative Fortner, do you believe that you are the person empowered to define your identity, or should the government define your identity for you?
I should define my own identity. It's mine to keep.
And Representative Fortner, do you realize that what this bill does is define your digital identity in order to secure your rights over your own identity?
That's what everybody says until if they say, well, you want to opt in or you want to opt out, they're going to say you want you to opt in. For example, I had a credit card company that I use just for gas purchases only, and I paid every month. And they said, well, we're sharing your identity. Do you want us to share your identity and call this number? I called the number 6 times and nobody answers the number. Once they get it, you lose it. No matter what they tell you, eventually somebody is going to fall in the wrong hands of somebody with today's technology.
Maybe it'd be helpful if we went back to the, I really like the driver's license example for this reason. So I don't know if you were here earlier during the driver's license example testimony, but driver's license is a state issued ID. So the state decides what you can put on your ID, not you, the state. The state decides that you're going to put that your daughter has her address on the identification card. The state decides that it has her picture on it. The state decides that it has her date of birth on it, all of this information. The chief example, and just help me understand if we're going in the wrong direction, but the chief example of using digital identity is that when I have my control over my identity, I choose what portion of my identity to release. So in the driver's license example, I don't have a government issued ID. I'm able to prove my identity simply by zeros and ones. And I offer only what the clerk needs in that example when I'm purchasing an IPA, a video, or whatever it may be. So help me understand how in that example, you don't have control over your identity and they, being the government, has control over that.
I guess the best way I can explain that is you give it to the first guy out of your wishes. Then that guy gives it to the next guy and that guy gives it to the next guy. It's sort of like blockchain is right now. Somebody down the line ends up with your information that you do not want your information to go to. That's the way it works. I mean, you got the first initial guy, you got to say, so to say, you can have this, but beyond that, it just keeps going right on. It's just like blockchain basically is right now, except the license, your driver's license is basically your ID. It's called for more than your social security number. And the way that all plays out is you have to reveal that. But as you're going into things like this right here, say you Facebooks, I'm not on Facebooks. I get my party that when I ran, they set a Facebooks up for me. My boy, he's got a Facebook because he's in Indonesia. But I personally do not own the Facebooks in my name. I never use them. But off of that, Facebook's been a worldwide web. Everybody in China, everybody in Europe, everybody in the world has access to your information. And that's because you bought into that. And it's
Actually, Representative Fortner, I think you just described the reason for the bill. That's the purpose of the bill, is that right now, my digital identity, our digital identities are unknown to us. They're defined by what's out in the digital world. By defining it and then wrapping rights around it, you get to decide what is out. So the Wikipedia, I joked about it, but the Wikipedia is the example. I didn't write my Wikipedia page. Somebody else did. I don't know who, but they got to define who Representative Jared Olson is by writing that page. So if I have a digital identity and I have rights to it, then I have the right to say, Wikipedia, you cannot publish what you believe to be the identity of Representative Jared Olson without my permission. And I think, so if I understand your concern right, I'm confused how the bill doesn't solve your problem. It's that's the digital identity it's already out in the world as you describe it. The purpose of this legislation is to wrap a definition around what it is that is you digitally, so that you can then have rights to protect your identity digitally, so that Facebook doesn't define that for you, Wikipedia, Google, etc. And I think the question really is, do you want to define your digital identity? Do you want to protect it? Or do you want big tech corporations to do that?
And the way I see it is totally different than the way you see it, because when you hire somebody to protect you, they could be protecting you, or they could give the evidence to somebody else that's not protecting you. How do you know? You'd have no idea 100% for sure if they're protecting you without giving your information out.
Questions for Representative Fortner? All right. Anyone else wishing to testify on this bill? Nope. In the digital world, in the virtual world? All right. Thank you, Representative Fortner, and I'll close public comment on this bill. Committee, what is your pleasure?
Move the bill.
Moved by Representative Yin, seconded by Representative Oakley. Discussion or amendments on the bill? Question on the bill? Question on the bill? Okay, will you please call the roll on Senate File 39, digital identity?
Mr. Chairman, would you like me to call the roll or the vote? I need to call the roll as
Oh
well.
my goodness, we never called the roll, okay?
No.
All right, let's call the roll, then we'll call the vote roll.
Okay, thank you. Representative Craigo,
Excused.
Representative Larson,
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Williams. Vice Chairman Washut.
Here.
Representative Yin.
Here.
Representative Swanitzer. Chairman Olson.
I am here.
Mr. Chairman, we have 8 present and 1 excused.
All right.
Okay.
Okay,
now-
I was so excited to get into the legislation that I skipped that. In the future, just throw something at me and tell me, stop, I need to take the roll.
Okay, I didn't want to interrupt, so this is just fine. We got it done.
All
It
right.
works.
Now can we please take the vote on Senate File 39, digital identity?
Yes, of course.
Thank you.
Representative Craigo.
Excused.
Oh, that's sorry. Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Williams. Vice Chairman Washut.
Aye.
Representative Yin.
Aye.
Representative Swanitzer. Chairman Olson.
Aye.
Mr. Chairman, you have 8 ayes, 1 excused.
All right. And just to clarify, Representative Craigo did not leave a sheet with you by chance?
No, I have nothing from him.
Okay. All right. Senator, are you presenting this bill to us, or would you like, is it Mr. Cave, or how do you want to? You not want Mr. Cave? You do not want Mr. Cave. You want to present the bill. He is in the digital world.
Mr. Chairman, thank you. Senators, or representatives, sorry. Transitioning, it's been a minute since I've looked at this bill.
Don't start off by demoting us.
Oh, God, thank you guys. It's, no offense, Mr. Chairman. Senate File 19, Public Health Emergencies Immunity Amendments. Good representatives, this bill really originates from the start of the pandemic and the special session that the legislature held in May remotely. At that time, the legislature, I'm going to give you the full overview, and poor Representative Washut has heard it so many times. At that time, the legislature heard three primary bills, primarily focused on the need to address the appropriation of the CARES Act funding that we received from the federal government. However, as a result of kind of the concerns regarding business immunity that was really originating from the federal level, there was a number of Congress folks who were hoping to make federal law associated with immunity for businesses. It became a very popular conversation and a genuine concern of our businesses here in Wyoming. And so at that time, some individuals brought some individual bills regarding COVID immunity for businesses. It really created kind of a hardship in our special session focused on the appropriation of those funds, but a compromise was made during that time, really addressing what immunity already existed in our laws, primarily focused on healthcare providers. So we've recognized in Wyoming statutes that when pandemics occur, and they do, or when a contagious disease outbreaks or different types of events occur, that those result in the requirement that normal procedures and protocols look differently, and that can expose some professionals to liability exposure. So we already put in our laws immunity for healthcare workers and entities in responding to pandemics. Of course, the concern was providing that to private businesses. And so an amendment was made into that statutory section in the special session, allowing for that immunity to apply to those businesses at that time. The requirement for that immunity to apply was similar or was the same for healthcare providers, which was that they had to be in good faith compliance with the healthcare orders at the time. Period. That's that story. Many in the business community and the insurance community felt that that wasn't enough, and lots of conversation about what does that mean to be in good faith and compliance, and that just opens up the door for extensive litigation. And so, as part of those efforts too, in the special session, the Joint Judiciary Committee agreed to take the issue up and focus its efforts. And so we did that in the interim. Unfortunately, and simultaneously, the Travel Committee did the same, further complicating and making a mess of things with two joint committees working the same concept in the interim and coming out with two different bills. There's a number of concepts, and it also resulted in, I think, poor work being done and kind of a confusing outcome. And so you'll see, looking at the bill in front of you, and the engrossed version of the bill. And so that's the bill that should be reviewed and carefully studied. And that engrossed version of the bill is primarily substantively as a result of an amendment that I provided to the original Senate File 19.
Yeah, Senator, can we just walk backwards just a little bit?
Sure.
So can you maybe start with what is the amendment that you made that makes this blue?
What is the amendment?
Yeah.
Well,
Your
Mr. Chairman,
committee-
you can
it was
find the amendment online and you can see it. And I'm about to walk through because it really is the bill. The amendment is the bill in substance. So the amendment really provided a number of new concepts. One, it expanded the application, I think, of the protection and the actions associated with the pandemic. In that same vein, it's limited to COVID, to just COVID. So this is not immunity coverage for the next 100-year pandemic. It is limited in scope to COVID. So that's one measure of protection associated with the immunity amendments that you find here, is it's limited in scope to that. But its application to conduct on the ground is broader than what you saw in the original Senate file as a result of the terms in this amendment. And I believe provides more coverage to both healthcare facilities, businesses, people, all of the above, and we'll walk through that. So in looking in the bill, you can see here, and I'm looking at it on my phone, so you'll have to forgive me, in section 1, the first title, COVID-19 exposure and illness. So that's where you can see in this particular title.
Yes, what I meant, Senator, was the whole bill is not your amendment. I believe it's subsection E. Is that?
No.
That's primarily what was amended into I'm not asking what was amended into the statute. I'm just trying to get the committee further past the background of the bill that we already heard and spent a lot of time in the virtual session and straight to what the change was that the Senate made, which I believe is the addition of subsection E. Page 7, line 15 through 18. And is there more than that?
I think it's significantly more than that, Mr. Chairman, but clearly you've walked through the bill and watched the special session, so I'll let your judgment be the best call of that. But if you want to talk about subsection E, we can do that.
Yeah, I think it's a good place to,
So
Just-
page 7, lines 15 through 18, that was already in the bill. So everything else in the bill was actually added pursuant to my amendment.
so I got it backwards.
Yep.
So when I pull up I guess I'm just confused. I just pulled up the bill online, the original introduced bill. So what amendment are you talking about when you say your amendment? Because I pulled up the bill. I'm looking at page 2, subsection D.
Mr. Chairman, do you want to just walk through the bill and not worry about the amendment? Maybe that'll be helpful. Walk through where we are. For who's a claimant under COVID-19 liability, and just start from the beginning. We'll just walk through it that way.
Sure.
Okay. So page 2, COVID-19, obviously there's the definition as found there. On line 14, page 2, COVID-19 liability claim means a cause of action for the transmission, infection, exposure, or potential exposure. So potential exposure is included. Romanet I, at any healthcare facility or any persons or entities premises. Right, so there's the business and it's expanded to everybody that in the state. Page 3, paragraph 2, caused by the actions of any healthcare provider or other person that resulted in injury or death to the claimant. So again, this is one of those protective measures caused by, it requires that nexus to occur. You need to actually be responsible for the conduct. 3B, line 5, acts or omissions by a healthcare facility or provider in arranging for or providing healthcare services or medical care to the claimant. So this expands, really, I think is more expansive to the scope of healthcare coverage. Line 13, manufacturing, labeling, donating, or distributing personal protective equipment or sanitizer, and all of those other pieces associated with the need to respond to the pandemic are there. Page 4, the definition of personal protective equipment. Line 7, sanitizer. Want to make sure that those folks who are trying to help on that front have those protections as well. Line 11, in any action involving a COVID-19 liability claim against a person or entity, there should be a rebuttable presumption that the claimant accepted and assumed the risk. So this is also new language. This is a new concept that was not discussed during the interim, but is provided for in the amendment for what we know in Wyoming law associated with assumption of risk, and primarily adopted from the Wyoming Recreational Safety Use Act. So that's where this concept comes into play on line 16. So upon entering the premises of another person or entity, or when one of the following circumstances occurred, and it goes through the person or entity issued the claimant a receipt or proof of purchase for entry. And here's the sign that goes up with the following warning. Any person entering the premises waives all civil liability against the owner and operator for any injuries caused by the inherent risk associated with contracting COVID-19 at public gatherings, except for gross negligence or willful or wanton misconduct. So why that language? What is that about? Why are we posting signs? And it really has to do with the same concept associated with the Wyoming Recreational Safety Use Act that's saying, hey, listen, if you go out in public with the ongoing pandemic, you're in the best position to protect yourself, and you're assuming the risk of being exposed to COVID-19 because no one can really protect you from that, whether it's, 1 mask, 2 masks, sanitizers, cleaning, there's still the potential for exposure, and that has to be known. So it's your choice to take that on.
Senator, that sign can be an actual sign, as you say it, right? It could be a physical sign. And I can put it on can I put it on a document? Or,
Mr. Chairman, I think that would be a waiver that you're thinking of, a waiver of liability and assumption of risk and a waiver, but certainly that would be a prudent action for an entity to do. But they can also do a sign in the same way that the Wyoming Recreational Safety Use Act does. So if you go to a ski resort or if you go to a rodeo, frequently you'll see this sign posted because we provide those same liability protections for those types of activities.
so I'm just thinking of like a physician's office or a hospital as an example. So I can have the sign right outside the front door. Big old, I don't know. I feel like the Ski Safety Act defined the size of the sign too, but is this probably does, but well, I guess my question is though, on the waiver, yeah. So can I not have the sign and my patrons come into my hospital and then every patron gets the same document that has my waiver on it? Or no?
Mr. Chairman, I think your question is if an entity does not post the sign, do they get the assumption of risk protections? That's legal advice. My opinion would be yes, I believe that they would, but certainly a court could make that determination. It would be my advice for those sophisticated entities to post the sign, as you can see there on page 5, lines 8 through 16. There's the specificity in our statutes associated with what that sign should look like. Again, this is not a new concept. I haven't incorporated anything new. It's taken directly from the Wyoming Recreational Safety Use Act.
Was any thought given to the buck and rider being on the sign?
Mr. Chairman, I think that would be a wonderful addition.
Go ahead, Senator.
So, Mr. Chairman, going on to page 6. So that's one concept that's new that was found in the amendment, that assumption of risk piece. The previous section of the bill really expanded that, which we walked through to kind of explain this, and you'll have to forgive me. I was coming from one meeting to the next here. Dealt with really pretty kind of standard negligence concepts though, and immunity associated with a pretty standard negligence type of case. So let's go into the 3rd section of the bill, page 6, line 8. Here it is additional immunity for those entities complying, those people and entities complying with health orders in good faith. That if it's demonstrated in the court that you have followed in good faith your local or your state or whomever is in a position of authority to provide health orders, that you are immune from liability. Then going on to page C. Here we go into new concepts on paragraph D. Any healthcare provider, person, or entity shall be immune from liability for damages in an action involving a COVID-19 liability claim unless the person seeking damages proves that the healthcare provider, person, or entity took actions that constitutes gross negligence or willful and wanton misconduct. So again, immunity applies unless a plaintiff can demonstrate that the entity was grossly negligent or willful. So here's another concept in the bill, page 7, lines 15 through 18, which garnered a great deal of controversy in every single meeting. And that's that Romanet E. Any acts or omissions constituting the basis of a COVID-19 liability claim shall be stated with particularity and shall be proven by clear and convincing evidence. The reason why that's garnered a lot of controversy is because that is a departure from the normal standard for negligence claims, which does not require clear and convincing. It's a preponderance standard. And so it's a higher claim that is outside the normal. And then also that the pleading has to be stated with particularity. Mr. Chairman.
Which, Senator, is somewhat of a departure, but there are some examples, I'm sure, of law where we require something more than a basic notice pleading, where we have, maybe not in Wyoming, I don't know, but I'm sure there are states that have required is a particularity standard, a standard that we're inventing here, or it's a standard that exists somewhere in some
Mr. Chairman,
Please.
Mr. Chairman, you'll typically see that in the federal courts. That's usually related to the type of cause of action. For example, if you're pleading fraud, needs to be pled with particularity. But it's not in the state court commonly, and I had discussions with some of the stakeholders about the need for that in the bill. I think it's probably 6 of one, half a dozen of the other. Not sure it makes that great of a difference.
You can tell us about section 3.
No, Mr. Chairman, no, I can.
Section 3 is actually one that I don't know if, I've been trying to wrap my head around it. And I don't know if I have an illegitimate concern, Senator.
There are some, Mr. Chairman, there are some stakeholders who would like the bill to be retroactive. It's another choice that you have in front of you is the applicability date or effective immediately or our standard July 1. Effective date is a policy decision for you. I believe having it be retroactive is asking for more trouble than it's worth. But that's my personal belief.
And then, so just real quick. So if it's not retroactive, what it means is that if I have a cause of action, some injury that occurred prior to the enactment of this bill, because we're talking about there is an existing statute. So, and I know you walked through some of that history, but it doesn't mean that I don't have a cause of action. It just means it's a little easier probably to get my cause of action into court because I'm not going to have to prove particularity. I'm not, my burden of proof isn't clear and convincing, it's preponderance. But it's still, but the statute, the existing statute still requires that it constitute gross negligence or willful or wanton misconduct. So that's still the same.
Well, Mr. Chairman, I think you're asking me to provide an opinion as to what a complaint would look like based on facts I don't have. So I think it would depend on the type of cause of action, if it's against a healthcare provider as opposed to against a business entity.
No, it's a great point because the healthcare provider is exactly where my concern is, because when I look at negligence in our healthcare world, we don't base our access into, or our bar on access or statute of limitations, in other words, off of when the injury occurred. We base it on when I discover the injury. It's a little bit different here because, and that's what I'm trying to understand if I should even have a concern center, because if I have an injury, I may not discover that for a year, but the injury occurred before the enactment of this date, and I discover it 1 year later. That's what I'm trying to figure out is where I'm at.
Interesting. I think probably the question would be if you are the healthcare provider or the business entity is, do I have the immunity protection? And so when does the immunity protection apply? And so if it happened in April of 2020, when the cause of action occurred, when the injury occurred, do I get to avail myself of the immunity protections associated in the bill? That would be my framing of the issue.
Okay. Do you have a response?
Well, it depends on what the committee chooses to do. As of right now.
With your bill as it's written.
Yep. So in section 3.
Yeah.
No, this bill is not in effect in April of 2020. So no, that would not apply.
But you think it's a can of worms to open that up?
I think it's risky when the ex post facto doctrine, which only applies in criminal cases. I'm fundamentally aware of that. But the rationale and policy decision associated with that, I think, is important. And, I would have concerns about the applicability of its retroactivity. And so for business entities and healthcare providers who are seeking clear and, finite, definite understandings regarding their exposure to liability, You know, I think that that is one area that lawyers would have a good time with, but that's my personal legal opinion.
Oh, they'll probably have a good time either way. But Vice Chairman Washit?
Thank you, Mr. Chairman. Senator, I'm trying to think back to the times I went to healthcare providers in the last year. And I don't remember seeing any of these signs posted on the doors when we went in. So I guess that compounds the idea of retroactivity. How do you put a sign up that wasn't there a year ago to invoke these provisions today?
Mr. Chairman, through you, Representative Washit, these are actually pretty complicated legal issues. It's my opinion that those assumption of risk defense protections already exist in the common law. And so regardless of signage or not. The business community is asking you for the greatest protections that they can get because they feel nervous about exposure to liability. And so these are some tools that we have available to us that we have seen in other areas where business entities have exposure to liability, such as ski resorts. And we allow them to avail themselves of these types of statutory protections beyond what's known in the common law for their comfort in operating.
Representative Yen.
Thank you, Mr. Chairman. Senator Nethercott, thank you. So you mentioned that we did put in some stuff in the special session, and it's been about a year. It's been over a year since the pandemic has started in the United States and in Wyoming. Have there been any lawsuits filed in Wyoming that you know of? And especially since we've been ideally through the brunt of the pandemic, have there been any lawsuits so far?
Senator Nethercott.
Mr. Chairman, to the best of my knowledge, no. They're not regarding this issue of tort liability. There are other issues associated with COVID. So you'll hear, lots of fear and a lot of fear that you've heard throughout the past year about the floodgate of litigation. Most of that litigation centered around breach of contract issues. For example, you bought a cruise for July 2020 and the cruise line canceled your cruise, of course, and you want your money back. And so, as a result of what those contracts said and disputes over that, there was a lot of litigation over constitutional rights associated with health orders and different types of actions by government entities. That's what we see a spike in litigation associated with COVID, not necessarily the tort liability pieces. Certainly there are some cases across the country, but in Wyoming, I'm not aware of any.
Representative Oakley.
Thank you, Mr. Chair. Senator Nethercott, mine's fairly simple. I'm looking at the last line, 22 on page 4, and it says in not less, and then it appears, I'm guessing there's some language there that's supposed to be about the font size. I gathered that from the next paragraph. Is that? So the last 3 words of line 22, page 4, in not less, and then I'm guessing there's supposed to be some language about font size.
Yeah, I was actually wondering the same thing because I feel like I read something that said in not less than 1 inch or some kind of font, but it's not in our bill. It's not a complete sentence, Senator, that goes from page 4 to 5.
And
Mr. Chairman, I do think maybe there's a technical typo there. That 1 inch size is found on page 5 in paragraph B.
Okay. But it should, okay, but going back to page 4, in not less with the following warning.
Mr. Chair.
Yeah, Representative Oakley.
Thank you, Mr. Chair. So I guess what I can do, if everybody is make a motion for it to match that with font not less than 1 inch in size, similar to lines 10 and 11 on page 5.
or if it has to be there, it may
Miss-
be that in.
Just,
that-
Mr. Chairman, so I'm looking up the committee of the whole amendment
And that's
from
where
the
it was.
Senate, and it is in the committee of the whole amendment. So this
Okay.
is an engrossment error from
I
us.
thought I read Senator Nethercott's amendment, so I thought I saw that there.
Yeah, I think it's just
that's
a technical error.
I think that's a technical correction, and I'll make a technical correction to it on the,
Mr. Chairman,
without the
on,
need for the amendment.
looking at it online, it is there.
Okay, so maybe it's just something to do with printing.
I think so.
We'll figure it out. We don't have to make the amendment if it's that technical in nature. All right. Vice Chairman Washington.
Thank you, Mr. Chairman. Senator, one more question. I think when I think of healthcare facilities and COVID, I think of that state on the East Coast where the governor's under attack right now for some other issues. And those long-term care facilities and those sorts of things. Taking that kind of scenario, recognizing it's a complicated legal environment, how would this bill apply to a resident who didn't voluntarily enter the facility, rather others were brought into the facility?
Senator Nethercott.
Mr. Chairman, Representative Washit, I believe you can find those protections. Really, what was originally what we did in the special session and what was already in law before, and that's found on page 6. And found in our healthcare code under 35.114, which is during a public health emergency. So even if you're a long-term care resident that was in the facility prior to the pandemic, you're continuing to receive care, and there is a public health emergency, that if the facility acts in good faith to comply with whatever health orders might exist, then that immunity applies.
Did I get your question? All right. Further questions for Senator Nethercott? All right. Good times. We'll move to the public now, Senator.
All right. Mr. Chair. well, I'm
Yeah,
s-
please.
Excuse me. Mr. Chairman, I
Yeah.
have a handout for the committee.
Who's that from?
Wyoming Business Alliance.
Okay. I guess we'll let you hand that out. All right. Now, let's go. Thank you. Let's bring up Business Alliance. Oh, you want to testify on this bill? Chairman
Mr.
Flintner?
Chairman, I just love it when you guys talk legal.
Oh,
Just don't expect me to do it.
Representative Sweeney.
Yes, Mr.
Well,
Chairman,
hello.
my name is Jamie Flitner. I am the chairman of Travel, Recreation, Wildlife, and Cultural Resources. This is a fellow representative, Pat Sweeney, on my committee.
Sorry, I didn't get your name. Sir, your name?
I'm Representative Pat Sweeney from House District 58. I'm backing up my good chairman.
He's my godfather. No, you don't need any backup.
You
But
can
Mr.
always-
Chairman, I don't
You
want
could
to
always
take up,
join the House of Representatives, Senator. Move up in life.
I don't want to take up too much time, but I just wanted to let you know that these ideas originated with your TRW committee in the interim, as you probably know. It was a concern brought by your Outfitters Association. And so, yes, we did work these bills in the interim. And then our committee worked House Bill 59, which you also probably can have for reference, but that's just a little background information. And I know there's people here that would like to speak to you because this is of great concern to the business community.
Thank you, Chairman Flintner.
And
Do we have questions for the chairman? Did you?
Just real quickly, Mr. Chairman, House Bill 59 went to general file and did not get off general file. Is that correct?
Mr. Chairman, that is correct.
So it's effectively done? Okay.
Did stayed in a drawer? Well, I don't remember
It didn't get,
discussing it. We didn't discuss it.
it was not brought up by yesterday before cutoff, so it's no longer in play.
I understand. Okay.
Mr.
Representative Sweeney.
Thank you, Mr. Chairman. So, yes, 59 kind of got pushed aside because of the good work in the Senate. And I think the good chairman of Judiciary on the Senate did a wonderful job of defending the work and really did straighten out a hot mess. So, and so I appreciate her good work and the committee's good work in the Senate. So, but I am new to TRW, and we worked what we were given in the chairman's defense. There were some new members, including myself, that fought very hard to keep it alive. We definitely, I appreciate the Senate's good work, and I appreciate your good work on this today. So thank you, Mr. Chairman.
Thank you, Representative Sweeney. We always do good work, the House Judiciary, but we don't come near as close to cleaning up the things that Senator Nethercutt has to clean up. If we could get her some help in the Senate one day, that'd be great.
Mr. Chairman, if I may, for clarity for how I started this conversation, the committee of the whole amendment is the bulk of the amendment.
Yeah.
So you can find that, and that's where it's a 4-page amendment.
Yep. I think I was slow to figure that out, but I figured out the committee of the whole amendment is actually the bill. Substitute bill. We just called it a committee of the whole amendment, but I'm up to speed now. All right, Senator. Anything else? Go to finish my public testimony. Dr. Harris.
Mr. Chairman, Dr. Harris is available for questions if the committee has any.
Questions for Dr. Harris? Welcome, Dr. Harris.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, Allie Harris, State Health Officer, Department of Health. Again, don't have testimony, wanted to be available for questions. Over on the Senate side, we had initially expressed some concerns about the original bill and how it impacted the immunity for liability for healthcare providers. Those concerns have all been addressed by the committee of the whole amendment.
Wow, making it easy for us, Senator. Thank you. Questions for Dr. Harris? All right. Thank you, Doctor. Okay, let's go to Business Alliance and Mr. Cave. I believe Mr. Cave is virtual.
Thank you, Mr. Chairman. Yes, my name is Cindy Delancey, and I'm the president of the Wyoming Business Alliance. And I would ask for your permission to co-present with our counsel and legal advisor on this very, very complex topic, Mr. Brad Cave, who is with the law firm Mulholland and Hart. If he could be admitted to the virtual room.
He's staring right over your shoulder.
Wonderful. Thank you. Members of the committee, just by way of quick introduction, due to our pandemic, I haven't had the pleasure of meeting many of you. So just a real quick introduction about myself. I am a proud member of the Wyoming Bar for going on 20 years now. I'm a former elected prosecutor and a former attorney who was in private practice for a significant amount of time. So I just bring that to you to let you know that I do have a legal background. I've worked very, very hard on this bill, as many of the stakeholders behind me, with 2 committees over the interim. And to put it mildly, to quote your colleague, Representative Sweeney, hot mess sums it up pretty darn well. So we've turned the hot mess into something that is legally defensible and something that is absolutely needed to protect businesses from frivolous lawsuits. You might recall before November, there was a lot of discussion about this issue being addressed at the federal level. However, that window of opportunity has closed and it is now up to the states to decide what we want as far as business protections. I want to be clear before I turn it over to Mr. Cave to kind of walk you through some of the legal analysis that this bill does not give blanket immunity. That is not what the business community is seeking. All we are seeking is to have some additional higher protections to keep us out of frivolous lawsuits and to be able to give the judge the tools in the toolbox to be able to let those meritorious claims move forward and the frivolous claims be dismissed. I just ask you to think about many of your constituents who are mom and pop businesses. Wyoming's business community is made up 90% of small businesses. If a small business was to be thrown into a lawsuit as a named defendant, they would be out of business. So what the issue is and why we feel we need these protections, and again, I'm trying not to get too in the weeds because this is a very complex and technical legal discussion, but the good work that was done very quickly, again, Senator Nethercott saved the day during the special session back in May with trying to afford business some kind of protection by initiating this good faith standard. Why we take exception with that is ultimately to determine good faith becomes a question to a jury. And so what the problem becomes is if a business is a named defendant, you have to litigate all the way till the jury question becomes of whether or not these activities that the business engaged in, 1 mask, 2 masks, hand sanitizer, PPE, shots, no shots, becomes a question of did that individual act in good faith. By passing this bill, it would give some additional protections for the court to be pleading with particularity, using the clear and convincing evidence standard for the judge to be able to get a small business person out sooner in the litigation if they didn't belong there. So with all due respect to Senator Nethercott, this pleading with particularity does occur in state court in fraud cases pursuant to Rule 9. This is a concept that we are familiar with in the law and another point of possible disagreement, which lawyers love to do, is the retroactivity. Sure, this is a very complex ball of wax. But to be able to close that statute of limitations window, perhaps from 5 years to 4 years, could certainly help by going back to when the public health emergency was declared. So we've been working on this for a very, very long time. 2 committees, hours and hours of testimony, multiple stakeholders support this bill. You're going to hear from our friends that on the other side, maybe the aisle, the lawyers that like trials, that they're probably not in love with this. But the business community certainly, we are asking for your favorable consideration as far as the necessity to keep our small businesses from going out of business. So with that, Mr. Chairman, I'd like to turn it over to Mr. Cave to address some of the legal questions, perhaps from the committee.
Sure, real quick, Ms. Delancey. One thing, because sometimes I have to take off my lawyer hat and put on a hat that kind of thinks a little differently. And I like how we keep referencing the Ski Safety Act. And I think it's particularly relevant right now in Wyoming because in February, there was an accident that resulted in a lawsuit. And I bring that up because I think sometimes when I take off my non-lawyer hat, the word immunity can be confusing because what we're saying is you're immune from a suit except for a suit and then. So it's really, in a non-legal way of saying it, it's really, there's a limitation on liability. Not everybody's barred from accessing court. I think you used the right, I really like the terminology used about the gatekeeping function. And I just want to kind of, using that ski safety example, I was here when we voted that into law. The idea was providing some types of really limiting liabilities, call them immunities, call them whatever you want. But at the end of the day, there's no such thing as blanket immunity. And this bill, and Senator Nethercott, I think you probably said that, but just driving it home, it's not a blanket immunity. It's do you qualify to access? We're turning back the dial on the gate and closing it just enough. So not frivolous, not all frivolous suits or whatever we want to call them, get through the gate.
Thank you, Mr. Chairman. You're spot on. That gatekeeping function is essential for a small business, particularly because unlike any other, many other lawsuits, if someone were to break their leg in front of your business or, your insurance company would be there to defend you. These types of pandemic situations, you're on your own. And I don't know about many of you, but myself as a small business owner, there is no way that my family business would be able to litigate, to the tune of multiple $100s an hour in legal fees for years to get to the question as to whether or not we did the best that we can to protect the people that were in our business. So you're absolutely right. No one is asking for a free pass here. No one is saying that the cases, if there was willful and wanton conduct, those should go forward. Bad actors should be held accountable, but we do need to close the gate just a little bit to keep our businesses whole. And Senator Nethercott has done an incredible job as far as parlaying this assumption of risk concept that we are very comfortable with in Wyoming. Our Supreme Court has opined for many years on this. And I love what she's done, in this social context of we are big boys and girls. If we want to leave our home to go to the store or the gas station or grocery store, we're assuming that risk because we are operating in an environment where I don't know about you, but I don't even know what to do. Like she said, 1 mask, 2 masks, wash your hands, stay away 6 feet, 3 feet. I think all of us are trying to do the very, very best we can. And by affording this kind of protection for us, just gives the business community the ability to stay in business and really focus on what that business is instead of being worried about, am I going to get sued because I tried to do the best I can and it wasn't good enough? So that's what we're asking you for here today is, as a matter of policy, let's stand behind our businesses, continue to be that business-friendly state, inviting people to come here knowing that they can do business, and that gate will be tightened just a little bit to make sure that we can stay in business through these difficult times.
Questions for Mr. Yeah. Oh, hi, Representative Yin. Go ahead.
Mr. Chairman, Mr. Delancey, thank you. I think I'll just ask the same question I asked to Ms. Nethercott. We heard this fear a year ago that there'd be lots and lots of frivolous litigation with regards to this issue. Have there been any litigation at all in Wyoming? Thank you.
Mr. Chairman, Representative Yin, my answer is no different than the chairman's no. But what the unknown still is in the law, we have what's called the statute of limitations, meaning that a potential plaintiff has a certain number of time to be able to prepare for that lawsuit. So just because we haven't seen any yet, we're not even close to the statute of limitations running on those cases. So we should, and that's comes for that. One of the documents that I handed out to you is a proposed amendment for retroactivity. By doing that, we're able to close that window just a little bit. Again, tightening that gate, ratcheting that back to go back to when Governor Gordon pronounced the public health emergency to give that protection for claims that could arise from that time. Because if we don't do that, as the chairman indicated, we're operating under a whole different set of standards. We're back to that good faith litigation question, what would happen if a claim was filed before, let's say if this bill was passed and the effective date on this. So just because we don't have any now doesn't mean they're not coming, sir.
Yeah, Representative Yin.
Thank you, Mr. Chairman. So then to provide an example of something that did happen, a constituent sent me an email. They said they have COVID and their employer, one of the larger employers in Jackson, didn't want to give them time off. This was in a time where you couldn't necessarily get tested. So you call the doctor, they say, you have symptoms, don't get tested, just self-isolate. The employer did not let them self-isolate and also knew that there were other employees in the same business that did not self-isolate. So my question to you would be, what would it take for that constituent to prove gross negligence to bring a lawsuit forward?
Mr. Delancey.
Thank you, Mr. Chairman. Representative Yin, I think we're talking about two different types of claims. That would be a little bit more of an employment type of claim as opposed to a negligence claim. A negligence claim has 4 elements which a plaintiff must prove. And going back to law school for sure, proud of myself, duty, breach, cause, and harm. So that's a different type of claim that a lawsuit would be, looking at, as opposed to an employer-employee relationship, which is what I believe you're referencing.
I think to Representative Ian's question, maybe it wouldn't be the individual constituent you heard from. Maybe your question is another employee who's at that business who, because the individual was not required to stay home, brought COVID to the workplace, gave it to another individual, what type of claim that other individual who now has COVID and, let's say, dies. Now the question is that enough for gross negligence? I think is that where you're headed, Representative Yin?
Mr. Chairman, so not just that situation, but because it was a retail establishment, for any customer that goes in the door who may not know that that's the situation in the store. I only know it because the constituent came to me, right? So if any person that goes in that store gets COVID, how high is the burden of proof for them to prove that there was gross negligence when I think I know it, but they would never be able to discover it, right? At that point, in that situation, Mr. Chairman.
Ms. Delancey?
Thank you, Mr. Chairman. Mr. Cave is probably
gonna say,
dying
you
to
really
jump
wanna
in,
bring
but,
Mr.
but
Cave
no,
in.
I'm certainly happy to answer that, but I think this in the essence of time. Mr. Cave deals with these types of issues, Representative Yin, day in and day out. He lives and breathes these. That's why we wanted to bring in the very best to help us get it right. So with your permission, if I could defer that question to Mr. Cave.
Also an employment law expert to the employment question. But
That's
that may
right.
be unrelated to the bill. Go ahead, Mr. Cave, introduce yourself, please.
Thank you, Mr. Chairman. I'm Brad Cave. I'm a partner with the law firm of Holland and Hart in Cheyenne. I've been with the firm 30 years now. As Ms. Delancey said, I do advise employers and businesses on these topics frequently. In response to Representative Ian's question, I'm also not aware of any Wyoming lawsuits. There certainly have been lawsuits outside of Wyoming alleging negligent liability for COVID-19 cases. Those have been brought against nursing homes, long-term care facilities, as well as cruise companies and meatpacking plants. And I believe there are others in the works. We haven't seen one, to my knowledge, in Wyoming yet. To respond to the fact pattern, if a employer or a business does not take measures to protect their customers from a known risk of COVID transmission, that failure to take action would certainly be something that the judge would consider in determining whether a complaint meets a standard of gross negligence or willful and wanton misconduct. In a case like this, if Senate file, if this bill were passed as it's engrossed, in a case like that, the community member who came into the business would bring forward the fact that this particular employee had COVID. They interacted with this employee. The business took no steps to protect the customer from that interaction. The business should have done so under health orders or guidance from their health department, et cetera. And a judge would review those facts and determine whether under the judge's interpretation of the judge's interpretation of the willful and wanton misconduct or gross negligence standards, whether that in fact stated adequate facts to go forward in the lawsuit. And I'll take a pause, Mr. Chairman, to see if I've answered that question before I continue to talk more about the bill.
Representative Yin?
Mr. Chairman, thank you, Mr. Cave. So ultimately, my concern is, do we, with this bill, I mean, I get that the goal is to try to filter out frivolous claims, but do we also block meritorious claims if they can't even get to the point where they can find out whether or not there is gross negligence, Mr. Chairman?
Mr. Cave?
Through you, Mr. Chairman, I don't think that you're blocking bills because a person can't find out whether there's gross negligence, or blocking cases, blocking suits. I think that in the law firm process, or I'm sorry, the lawsuit process, a plaintiff would need to have enough information to know where they believe they acquired COVID and how the business was responsible for that. The stated with particularity standard that is in subparagraph E on page 7 of the engrossed bill requires that a plaintiff allege the who, what, where, when, if you will, of their exposure to COVID. What were the facts and circumstances that caused me to get COVID? And in this situation with COVID in particular, that's a necessary requirement. A business cannot know which customers are bringing COVID onto their premises, no more so than they can necessarily know which employees may have COVID. The employees and customers themselves may not know that they have COVID. They may be asymptomatic. So where we have a disease that has that can be transferred while asymptomatic or has asymptomatic characteristics like that, the requirement that a plaintiff be able to tell you, I was in your business, this is who I interacted with, I believe I acquired COVID from that person, and here's why I believe that. That's a standard that we think is important to separate those claims that may be adequate under the gross negligence or willful and wanton standard. Starting the litigation process is really the way that would be challenged is a judge would review a motion to dismiss that's filed by the business. That motion to dismiss under current law, the judge would look at that complaint and the judge would decide if there's any possible way that the allegations of the complaint could lead to relief being granted to the plaintiff if you assume all of the allegations to be true. It's what we call notice pleading. And so the ability to stay in court under current law is very easy. The hurdle, the bar is very low. And then the business is required, as Ms. Delancey talked about, to litigate that case all the way through discovery and experts and et cetera, until they can file a motion for summary judgment to further test the evidence. And so that's really what the bill is designed to do. Subsection E in particular is designed to do is to give the judge the tools to test those allegations and determine whether there are particular facts stated about the exposure, and give businesses an opportunity to weed out those cases that could in fact turn into gross negligence or could in fact result in proof of gross negligence or willful and wanton misconduct. It doesn't, it's not going to weed out cases where an employer disregards a known health hazard, a known risk, and a plaintiff brings that forward as the cause of their COVID infection. The definition of gross negligence is disregarding a known risk that poses a substantial probability of harm, and substantial harm with that. And so in the case where you have an employee who has COVID and the boss knows about it, that's going to be a pretty difficult set of allegations to overcome in the context of a COVID-19 lawsuit. The other part of subsection E is the clear and convincing evidence standard. The clear and convincing evidence standard is already a standard that's used in Wyoming law. It's a standard of proof. That would come into play when a lawsuit goes to a jury. The judge would instruct the jury about what clear and convincing evidence means. And what it means is it means a level of proof that persuades the jury that the allegations are highly probable of being true. Highly probable of being true. So right now, in most lawsuits, the standard is preponderance of the evidence. It's more likely than not to be true. We're asking that the standard for COVID-19 liability claims be highly probable of being true to overcome those great uncertainties that we have in the course of how COVID is transmitted and how people catch it. So we think that's an important component part. This clear and convincing standard, as I said, it's not new. It applies when a licensing board acts to try to take a person's professional license away. That has to be done by clear and convincing evidence. It applies in the termination of parental rights. It applies in fraud claims if somebody claims they've been defrauded in a lawsuit. So it's an existing concept under Wyoming law. We're simply borrowing it and suggesting that it be applied to these claims. Likewise, the stating with particularity concept is also present under Wyoming law. It's stated just like that in Rule 9 of the Wyoming Rules of Civil Procedure to apply again to fraud claims and to apply to situations where somebody tries to get out of a contract by claiming that they were induced into their contract by mistake. So in those two particular situations, and there are some others as well, but they're more limited. So we're using these concepts that already exist in Wyoming law to, as Ms. Delancey put it, to close the gate a little bit, to give businesses an opportunity to respond to claims effectively at the early stage of a lawsuit so that they don't continue on and ruin the business through the expense of litigation. So with that, Mr. Chairman, I'll stand for questions.
Vice Chairman Washit.
Hey, Mr. Chairman. Sir, it seems that some important parts of this bill pertain to posting of signs and printing of warnings on tickets for admission and those sorts of things. And how many businesses in Wyoming posted such signs or issued such warnings last March and April? It seems to me if we're going to try and make this retroactive, you can't go backwards and post signs that weren't there in March and April. So essentially the retroactivity aspect is for the assumption of risk language and for the preponderance or the clear and convincing evidence standard and the claim of particularity. Is that correct?
Mr. Chairman, Representative, yes. I would agree that the retroactivity would only effectively apply to subsection D and subsection E of the engrossed bill. The signage is only going to be a prospective measure that businesses and entities can take.
Other questions for Mr. Cave? Thank you, Mr. Cave.
Thank you, Commissioner.
Thank you, Ms. Delancey.
Mr. Chairman, we would hope that you would entertain that retroactivity amendment, should the committee so choose.
Yep, committee, you have that in front of you. When we get to working the bill, we can discuss it more. And certainly if you want to flesh that out with any other presenter, you certainly can as well. All right. Okay, county commissioners.
Good afternoon, Mr. Chairman, members of the committee. I'm actually not here in my capacity as county commissioner. You'll notice I'm wearing my white badge today. My name is Bill Novotny. I handle government affairs for the Wyoming Outfitters and Guides Association. I believe you heard them mentioned earlier.
See how that's confusing?
I know. We don't spend a lot of time in front of Judiciary, so I just will let you know that Wyoming Outfitters and Guides, we're the trade association for big game hunting. We have membership that includes dude ranchers, walk wade, fly fishing trips, horseback rides, National Outdoor Leadership School. We've been in existence for over 60 years, and we are a major component of Wyoming's $2.96 billion tourism industry. So I'm here today on behalf of my membership, who the best data that we have, the most recent data, we're responsible for 8,755 experiences in the Wyoming travel and tourism industry. We stand firmly behind this bill. We applaud the work that Chairwoman Flitner did on this over the interim, the work that's been done with the good chairwoman from Senate Judiciary to bring this bill before you, because we really believe this legislation is critical. Because right now my membership faces 8,755 potential COVID lawsuits. And these would be frivolous lawsuits. We had to operate during the pandemic. Hunting season can't be canceled. We can maybe refund your deposit on your trip, but we have no control over what the Wyoming Game and Fish Department does with that hunting license. We operated in the most safe and effective management practices and procedures as possible during the pandemic to keep our clients safe. Now, we're doing that under the watchful eye of the federal land management agencies that oversee many of the permits where our folks operate, whether it's on the National Forest or the Bureau of Land Management. So we had a whole nother level of bureaucracy looking over what exactly my members were doing to make sure that the public was safe and could have a quality tourism experience in the state of Wyoming. We just would urge you, and I know we're coming up on the time crunch here when you have to go back in. So I'll just yield with the fact that we need this statutory protection. We have protections scattered throughout statutes that protect us from normal operating procedures. COVID was not a normal operating procedure. There was not a manual. We've got a manual on what to do if a grizzly bear attacks. We do not have one for a pandemic, which is why we critically need this liability protection so that my membership is not subjected to frivolous lawsuits when we did the very best in our standard of care to make sure that our clients had a good and safe experience here in Wyoming. Thank you.
Mr. Novotny, should this act apply to actions or causing an injury on or after the effective date, or should it apply to the moment the governor put his name on the papers to sign the orders?
Mr. Chairman,
from your association's perspective,
as that will be the policy decision that you will make. We would love to see the retroactive. You're going to shrink our time for statute of limitations down by basically almost a year. I think of the hunter that travels to Wyoming and maybe picks up COVID in the airport or in a gas station or after the experience. So the more protection you can give us by limiting that window of exposure to liability, the better.
Yeah, to me, this is where we start to separate from the concept of the Ski Safety Act, where it's okay, like we've had these mountains, we've been skiing, we've been doing all these things, and now we're going to put in place some limitations on liability, and we're going to say everything going forward. To me, liability on COVID-19 is so much different because really it's not like, hey, we were doing all these things, life was going on, and all of a sudden for years now we decide we want to do something. The door opened the moment those orders were signed, at least from my perspective. And so that's what I'm trying to figure out is when the right time, when it would make the most sense.
Good, Mr. Chairman, I will not haggle over the start of it. We just desperately need the additional protection.
Okay. Thank you.
Mr. Chairman, members of the committee, Lee Livingston, board member of Wyoming Outfitters and Guides Association, outfitter from up in northwest corner of Wyoming, been doing it for 36 plus years. I'm going to liken this, and the good chairman referenced this earlier, it's not a blanket immunity. I'm going to liken this to the Recreational Safety Act, and I operate under the equine provision of that quite a bit. I've got 50 head of horses and mules. It says that someone that comes and partakes in an activity with me and climbs on one of my horses accepts a risk, but it also protects them. It doesn't mean that I can put them on an unbroke 3-year-old, and if they get dumped on their head, I can say, I can stand behind the Recreational Safety Act. So I believe that this is the same sort of thing. It's saying you're taking a certain risk, but if we in all good faith, as outfitters and operators out there, try to protect you and do our best to protect you, it's going to protect us from a frivolous lawsuit. So again, I hearken it back to the Recreational Safety Act and in particular the equine portion of that Thank you for your time.
Questions, committee? All right. With that, we're going to hit the pause button on this bill. This good little Senate File 19 is going to be carried over to tomorrow at 8 a.m. We're going to be, I think we're on third reading. We're on education, and that bill's getting heard today.